In this video, I'm going to teach you the basics of copyright law so you don't get caught out here slipping with your content on social media. What's up everybody, this is Shontavia from Shontavia.com, and I wanted to do a quick video about copyright so that you understand the basics so you don't get caught out here slipping, and so that when you're on social posting your videos, your photos, your captions, and your content, you don't get caught out here slipping. You don't let other people get caught out here using your content in a way that you will be upset about. Alright, so let's jump right into the basics. So copyright law requires three things for your content to be protected. Your content has to be original, it has to be considered a work of authorship, and it has to be something that we call fixed. So in terms of originality, what does that actually mean? It means you haven't copied your work from somebody else. So this is your independent creation, something you've done without copying anybody else's work. And there's a minimal degree of creativity. And so I should actually go back to the independent creation piece. So when I say you haven't copied somebody's work, that means you haven't copied someone's work illegally. Now maybe you're using work that is not protected by copyright, or maybe you have permission, or maybe you have a license. So when I say independent creation, that means you've either done it yourself or you've done it in a way where you have permission. And then with respect to that second requirement, a minimal degree of creativity, that just means a minimal degree of creativity. It doesn't have to be smart, it doesn't have to be new, it doesn't have to be fancy, it doesn't have to have what we call aesthetic merit. It just has to be minimally creative, and that's a really low bar. So if you just like draw a squiggle on a page, maybe that doesn't meet the minimal level of creativity. There's a really famous case that basically says if you have names and you put them in alphabetical order, like in a phone book or in a directory, that doesn't meet the minimal degree of creativity. But you know, what is art? Who knows what art is, right? And so minimal degree of creativity is a little bit subjective, but just realize it is a really, really low bar. So originality. The second requirement is that you create a work of authorship. So the work of authorship is actually a legal term that's outlined in Section 102 of the Copyright Act. And basically there are these different categories. There are 8 or 9 different categories listed in the law where our legislators have said these are the things that are protected by copyright. Literary works, so like your books, probably some of your social media posts, your poetry, your music lyrics, captions, those types of things are literary works. Musical works, so obviously music, songs, audio, that kind of thing, including any accompanying words. So if you have song lyrics and you have audio or music, that would be considered a musical work that's protected. Dramatic works, including music, pantomimes and choreographic works, pictures, graphics, sculptural works, motion pictures, so like movies and films and that kind of thing, lives, sound recordings, and architectural works. So that's a pretty broad list, right? So when you saw those lawsuits about dances on TikTok or dances in Fortnite, they sound a little silly maybe at first blush, but these are really serious copyright issues about what the scope of legal protection is, and the law is pretty clear that certain things are considered works of authorship. Now the one little tweak in the law is that you can argue that new different things should also fall within this list. Copyright law is old, we are innovating really quickly, so like one thing that doesn't appear in this list that is copyrightable is software. So that's something that doesn't appear in the law. Law has not been edited, at least Section 102 of the Copyright Act, but software is copyrightable. So if you have some new innovative things that you think should be subject to copyright law, you can make that argument. Not everybody wins though. So there was a lawsuit several years ago about whether gardens could be considered copyrightable, and the court said no there, in part because flowers kind of grow the way they grow. So work of authorship is the second category. It's a broad list. You can argue to have other things included in that list. And then the final requirement, the third requirement for copyright law, is fixation. So the legal kind of terminology that you might see a lot or hear from lawyers is fixed in a tangible medium of expression such that it can be perceived for more than a transitory duration. That's a mouthful, right? But essentially that means we have to be able to perceive or sense or experience your work in some kind of way. Maybe we can read it, maybe we can touch it, maybe we can feel it, maybe we can hear it. Some of those auditory senses have to be used for more than a transitory duration. That means momentarily. So like, for example, if you blow a bubble, that bubble lasts for half a second or a quarter of a second or whatever, that bubble would not be considered copyrightable, because even though we can see it and perceive it, we can't do that for more than a transitory duration. So where this might apply to content creators, especially like musicians, is freestyling. Unless you've written down the lyrics of your freestyle or you're simultaneously recording that freestyle, a freestyle would not be considered copyrightable. So those are the three requirements: originality, work of authorship, and fixation. So there are some things that are not protectable. So if you meet all those requirements, you have a copyrightable work. But there are some things that are not copyrightable. The two I want to mention here are facts and ideas. So don't ever say I want to copyright my idea, because you don't really copyright your idea. What you can get a copyright for is the expression of the idea. So if you have an idea to write a book about the life of Martin Luther King Jr., then that idea in and of itself is not copyrightable, but the way you write the book would be considered copyrightable. Along those same lines, facts are not copyrightable. So the fact that Martin Luther King Jr. spent a lot of his life in Atlanta, Georgia, and went to Morehouse College is a fact. So that in and of itself is not copyrightable. But the way you choose to express that fact in your book, if you're writing a book, would be considered copyrightable. So the words you use, the way you describe it, if you talk about his experience in Atlanta or at Morehouse College, those types of things would be considered copyrightable. So who cares? Why does it matter if you have an original work of authorship that is fixed in a tangible medium of expression? And the reason people get really, really serious about the things they've created and their copyrightable work is because of what you get. So what do you get once you have an original work of authorship fixed in a tangible medium of expression? There are two things I want to tell you about. But if you like this video, go ahead and hit that like button for me. Go ahead and subscribe if you're watching this on YouTube, so that you can get more information like this from me day after day. So the two things you get with respect to an original work of authorship fixed in a tangible medium of expression: number one, you get control. You get a lot of control over what happens with your work. So the law outlines all these different rights you get once you have a copyrightable work. So you get to decide how that work will be reproduced. You get to decide if there will be any new things based on that work. So derivative works is what they're called. So a remix to a song, a sequel to a movie, a film based on an adaptation of a book. You get to decide when, where, and how that happens. And you may do it yourself, or you may want to take money to give someone permission, maybe a license where you just essentially give someone permission to use your original copyrighted work, or maybe you want to sell it. You assign your rights in a copyrighted work to someone else. And so you get all these different rights. I won't go through all of them, but especially for content creators and entrepreneurs and people creating lots of content online, those are the big ones: the right to reproduce, the right to create derivative works. Another one that's pretty big for musicians is the right to perform the work publicly. So you get to decide when, where, and how your music is going to be performed publicly. And people have to get permission from you to be able to perform your work. So you get all these different exclusive rights. The other thing, And this is where some people get a little bit caught up with copyrights, is you get those things automatically. You do not have to file a copyright application. You don't have to hire an expensive lawyer. You don't have to do any of those fancy things to get a copyright in your work. It happens in the United States, at least, automatically. Now, there are real benefits to registering your copyright and getting a registration number for your copyrighted work, but it is not something you have to do. So you get this automatically. All these different rights, you get those automatically. And why does that matter? It matters, again, because you can make money off of your work. You can control how your work is shared, how it is, not so much how it's consumed, but how it is shared with other people, how it is performed, and whether or not you choose to receive compensation is completely up to you. Also, if someone violates your rights, you can take steps to stop those violations. Now, maybe you can file a lawsuit. That can be pretty tough for the average everyday creator, in part because copyright lawsuits are really, really, really expensive and time consuming. A few years ago, the American Intellectual Property Law Association did a study that showed the average cost of a copyright lawsuit is about $300,000. So rushing out to get lots of copyrights and assuming you're going to be able to stop everybody from using your work immediately and threatening litigation if they don't, and using the threat of litigation as kind of like your sword, is not always the best approach, because unless you have lots of money lying around, or unless you have the backing of a very wealthy company or individual, it's going to be really, really hard to file that lawsuit, get into a federal court, and get a judgment against that alleged infringer. That $300,000 or however much it is can be a real barrier for a lot of people. There are some other options in terms of lawsuits, but the other real value, especially for content creators, is that if you're online, you can reach out to the website that is hosting, if it's a blog or a website or a social media account, you can reach out to them and ask them to take down the allegedly infringing work. And they have a legal obligation. So the internet service provider, whether it's a social media company or another website or whoever, they have a legal responsibility to take action once you let them know that there's allegedly infringing work on their site if they're in the United States. So I wanted to just hop on and give you that basic information about copyrights, because I think it gets confusing sometimes. I think people kind of get lost in translation with all the different legal terms and jargon and all of that. If you like this video, please subscribe to the channel. Please click like. I share information like this a lot. I want to make sure that you are creating your side hustle, your business, your entrepreneurial endeavor with all the right information. Thanks for watching.